Good to go, Tom.
Okay, thank you. Before I open the hearing for the Barnstable Conservation Commission, I would like to ask George to do a roll call for the quorum purpose.
Abadili,
Present.
Foster,
Present.
Gilmore present, Hearn,
Present.
Lee,
Present.
Zampu,
Present.
Pagney,
Present.
Administrator Darcy Carley,
Present.
Staff Member Kim Kavanaugh.
Present.
We are all here tonight, Mr. Chairman.
Thank you. Acting under the provisions of Mass General Law, Chapter 131, Section 40, and or Chapter 237 of the Code of Town of Barnstable, the Barnstable Conservation Commission will hold public hearings on Tuesday, February the 6th, 2024, at 6:30 p.m. for the applications of Laurie Porfiro Sperry, the Beach Club, Dewey Garden LLC, Anthony Ambrogio, and Anchor Via Sopolos, B. Francis II, and Patricia E. Soul. The hearing is being recorded and broadcast on the Town of Barnstable's Government Access Channel. The plans and application are on file and may be reviewed by scheduling appointments by sending email requests to Darcy Curley at 230 South Street, Hyannis. This meeting is being recorded and broadcasted on the Town of Barnstable's Government Access Channel. In accordance with the Mass General Law, Chapter 38, Section 20, please let the chair know if anyone is recording this meeting. Hearing none, this evening's hearing agenda is posted on the town's website. On the agenda, next to each application is the amount owed to the Town of Barnstable for the cost of advertisement. Please send your checks to the Conservation Divisions at 230 South Street before the hearing. Remote participations. The Conservation Commission's public hearing will be held by remote participation as a result of an act extending certain COVID-19 measures adopted during the state of emergency signed by the governor on March 29, 2023, suspending certain provisions of the open meeting law. Remote public access to this hearing shall be provided in the following manner. 1. The hearing will be televised via Xfinity Channel 8 or High Definition Channel 1072. It may also be accessed via Town of Barnstable's Government Access Channel. 2. The real-time public comment can be addressed to the Conservation Commission utilizing the Zoom link 847-5313-2635 or use the toll-free phone number 888-475-4499 as shown on the agenda. 3rd, the public can also email the comments to darcy.curley@town.barnstable.ma.us at least 8 hours prior to the hearing. Tonight, under the RDA, the applicant for the Anthony Ambrogio and Anchor Via Sopolos has withdrawn the applications. The first item on the business is the old and new business. The Conservation Commission's legal training with Assistant Town Attorney Kate Conley. We are lucky to have Kate giving us this legal training. I don't remember that we have formally any legal training since I joined the commissions many moons ago. I think in the past, like John had a chance to have, with previous town attorney Bob, to give him some training. So welcome, Kate. The floor is yours.
Thank you, Tom, Mr. Chairman, and members of the commission. Kate Connolly, Assistant Town Attorney. This is a presentation that's quite long, and I've divided it into a third of its normal. I'll be doing more presentations for you guys because I divided this one up to cover some of the most important and basic topics, and then we can schedule at least one more training. That may be all we need, but maybe more than that. And I'll certainly take questions. I just kind of want to go over some of the basics mainly for the new members of the commission. And I don't know all of your backgrounds, so you may have a lot of training in this area. Can I just ask, how many members of the commission are in a science field? And of course, I can only see 4 of you. I know some of you have legal training.
So Pete Sampu does.
I do. I have science training.
So
And I have science training.
4 of us.
At least 4. Yeah, and I know some of you existing commissioners have helped me out on reviewing briefs in litigation that we've had, and we'll talk a little bit about litigation, but it is helpful to have members of the commission that have science, math, engineering, that sort of training, legal training, obviously, as well. So I did go over some of this with Tom. There are a lot of statutes that apply to conservation commissions. I'm only going to talk about a few of them tonight. Some of them aren't relevant to this commission because you've got staff that does things like enforcement. So we're not going to talk about enforcement. But I want you to be aware of the general things that every town board, commission, and otherwise need to be aware of. The open meeting law, and that's how you conduct your meetings. The conflict of interest law, which is an ethics statute. And I'm not going to talk about that tonight. We may get into that at one of the later sessions. And the public records law was not one that your chair and other members thought was something that we needed to talk about, because that's typically when people make public records requests, staff and the legal department reply to those. But the one thing I will say to you is to be really careful with emails and texts, because a lot of times people don't think that those are public records, and they really are. So if you're texting or emailing about anything related to a matter that's before the Conservation Commission, then you've got to be careful how you word it, because if I get a public records request that's specific enough, I may have to give up a text or an email that you'd rather the public not see. The two main statutes that govern Conservation Commission's authority, you're probably somewhat familiar with: the Wetlands Protection Act, which is Chapter 131, Section 40, and the regulations that are promulgated at 310 CMR 10. And then the Conservation Commission Act, which is Chapter 40, Section 8C. The other one listed there, Chapter 4453G, that's consultant fee funds. And I'm not sure if you guys have that, but that's something we can talk about a little if you do. It's when you get a complicated application before you, if you've got a consultant fee bylaw, you can require that the applicant pay for a consultant. And then, of course, the local ordinance or bylaw, in this case, it's an ordinance. And we'll talk a little bit about what's the difference between issuing a decision under an ordinance and under the state act, because as this commission has learned in the last few months, or maybe the last year, we've had some litigation that has involved the same exact application on the same property. And yes, you can have a different decision under the act than you have under the local ordinance, because the local ordinance is allowed to be more stringent. So you can grant something because it complies with the basic minimum statewide standards of the Wetlands Protection Act and still deny it under the local ordinance. So the next pre-hearing, thanks, Darcy. When you get an application, and again, some of this, if it's really just what the staff does, the commission might not need to know what's going on behind the scenes. But one of the first things that the commission staff will do, Darcy and her employees, will look at the application, see if it's got everything it needs, including the application fee. So you look at what they're asking for, and this is actually written saying that at a minimum, you should say that the application, should say the specific relief sought, the statute or the bylaw provision under which it's sought, and the statutory factors that permit the board to grant relief. That's actually a really general slide that covers all kinds of boards, not just commissions. Next slide, Darcy. Applications that you're going to get before you, the two main things, there are other types of applications, but the two main ones will be notices of intent and requests for determination of applicability. Usually notices of intent, are when the applicant knows that there are wetlands on the property that are going to be impacted by the application. Requests for determination of applicability are, does the Wetlands Protection Act and our local ordinance even apply to this project? So it's a cursory review. And that one, you've got to be very careful to meet what we started calling the 21-day requirement. It's in the regulations. It isn't anything new, but it's something that there's new case law on, because there are certain applicants who have sort of, not just in this town, I'm saying all around the state, there are applicants who have tried to tell commissions that, oh, I'll grant you a continuance And you can't do that. The regulations at 310 CMR 10 are really specific that a request for determination has to be acted upon within 21 days from its submittal to the Conservation Commission. So if an applicant asks for a continuance, or if the commission needs more information in order to issue a decision, you can't ask for a continuance. You can't go past the 21 days. And if the applicant refuses to give you whatever information you need in order to make a decision within 21 days, you have to deny it. You have no other choice but to deny it. Because if you don't make a decision, they get to bypass the Conservation Commission and go straight to DEP. It's sort of what we call in the zoning and planning context, constructive approval. And that's where the body that the application is before fails to act on it in accordance with whatever the relevant statute is. And here it's the Wetlands Protection Act and 310 CMR 10. You have to act within 21 days or you lose your opportunity to act. And they get to go straight to DEP. Other notice, moving to the next slide, basically just talks about the reason for notice requirements is due process. That's to give the applicant an opportunity to be heard, but also to give all of the neighbors, particularly the immediate abutters, adequate notice of the application that their neighbor wants to build or whatever the neighbor wants to do so that they can be present at the hearing. And then you've got to have a fair and impartial fact finder, meaning the commission. When you hold your hearing, you've got to listen to the applicant. You can have certain rules about how the hearing is conducted, and you can't let people go on ad nauseum and repeat things, but you can, or you should, let everybody have a chance to speak on relevant matters. The contents of the application, again, that's something that staff is going to look at, including the name of the property owner, in addition to whoever the applicant is. But as you know, under the Wetlands Protection Act, someone besides the property owner can be the applicant. And you may have, you all may be familiar with the fact that we've talked about for this commission having a signed statement that applicants can sign at the beginning of their hearing process, where they state who their authorized representative is, so that if the applicant's not there, the property owner isn't there, I should say, and the applicant is a consultant, you want to know that you've got the authority from the property owner to grant a continuance or whatever it is they may be asking. And that comes out of case law as well. And I've warned this commission from some situations we've been in the past. Obviously treat every applicant the same, but be really careful if people are asking for continuances that you make sure you know who the actual authorized representative is, so that you don't have the property owner coming back later and saying, oh, I didn't authorize that continuance.
Kate, may we ask a question, or would you prefer for us to hold them?
No, you can go ahead and ask questions.
I really don't want to interrupt your
That's
presentation.
okay,
Okay, on that, as I understand it, if we have this duly authorized in writing that Letitia, the consultant, represents the owner, and Letitia asks for a continuance, is that adequate, or do we need to get something from the actual property owner? Or is under the agent's theory of agency, is that sufficient for the continuance request?
In the beginning of the whole process, with every new application, you should have them sign. I don't have a copy in front of me, but we did work out a document that every applicant can sign where they state who their authorized representative is. Then the authorized representative has the authority to grant or request and accept continuances.
Okay, and we could rely on that.
You should be able to rely on that. Yeah.
Okay.
If they sign it and we end up going to court, yeah, we'd argue.
Okay.
And we'll look at these on a case-by-case basis. There may be situations where, if we're at all worried that they're, maybe it's an applicant that you've had a history with, and you may think, oh no, they're saying they agree, but not really sure if I trust them on that. And then you might want to go back to the property owner. But that's why we created this document that has the property owner, when they file the application, signing it and saying, this is my authorized representative for, I forget if we put for purposes of continuances. I think it was just like generally for everything. This person can speak on my behalf with respect to this application.
would that same theory apply to permission to go onto somebody's property?
That's a good point, and that's a sort of a separate issue. There's case law on that too, the Grant case that actually caused DEP to amend the regulations many years ago. I would still, every time the commission wants to inspect a property, even though an application is sort of implied consent, you should still get a reasonable time and day, call the applicant or the owner, whoever, whoever you need to deal with based on what they signed on that form. If it's got to be the property owner, and it may be, because if they're home and people are going to be coming on their property, they might want to know that. So I would still recommend, so that you don't have a trespass action brought against you, that the commission and or its agent get permission before you go on the property every time you do so. It's the Fourth Amendment to the Constitution, which is the private property trespass concern. And I actually had a situation like this happen with a conservation agent many years ago. He was found liable for criminal trespass. It was another town on the Cape. And it wasn't even an application before him. He was out on a canoe on town-owned property checking the herring run because he had gotten a complaint that there was something was stuck or there was an issue. And he docked his boat on what he thought was still town property and went walking. And a property owner waved at him. Everything was fine. But then he saw the no trespassing sign, realized, oh, I'm on somebody's property. And he left. And then about 9 months later, the property owner on that property had an enforcement action against him. And all of a sudden, he brought a criminal trespass action against the agent from that day that he saw him on his property.
Wow.
And I didn't handle it, but it went to court, and that's a very specific statute. And as long as the property's posted, which it was, somebody can be held liable for criminal trespass. So I know that's an extreme example, but and I know this is probably somewhere later in the discussion, but that's fine. We can discuss it now and skip over it. What we usually advise is what's called the plain view doctrine. The three best ways to look at a property where you think there might be a violation, or not an enforcement situation, but just you have an application before you and you need to see the resource areas, you need to see where the proposed work is. The applicant's permission is the best way to go, with the property owner, whichever one is the one that's talking with the commission and making decisions. So that's the first thing. Second, which is really just if it's an enforcement issue, is from a neighbor's property. And typically when there's an enforcement issue, it's because a neighbor called it in. That's often the way those start. So neighbors are usually willing to let you onto their property. And then the third is the public view or plain view doctrine. And that is, if you can view the property from a road, or now with technology, although DEP cautions people because they're still working on this, people are using drones. And that, so far, courts have not found that illegal to view somebody's property with a drone to see if there's a violation going on. But anyway, those three are more for enforcement situations. The one where somebody's got an application before you, that's implied consent for you to go on their property, but you still should work out a time and a place to go on the property, just so that you don't end up having yourself in a trespass situation.
I think it was with your help that we developed a form, which is fairly new, where there is a signed consent form, right, Darcy, that we have on every application allowing us to go on the property. I thought you developed it actually, Kate, maybe not.
I think I might have, because I know I've done them for other towns.
We have a property access form that we make sure that it's signed by the property owner, or a DocuSign form. It has to be signed by the property owner.
Okay. Even though they have an appointed agent, authorized agent, we still require the property owner, Darcy, to sign it?
Yeah, it would have to be, we'd have to have a letter saying that they have somebody like a legal representative as like an executor or something. We'd have to be notified that in the beginning.
Okay. But it's not good enough if a consultant signs the form after submitting it. I am legally representing Letitia, the owner. That's not adequate.
If we get a letter when they submit the notice of intent, the consultant would have to have a letter from the property owner that they are the legal representative for the whole thing. We don't see that very often, but we've been a stickler with the property access form.
And
It
I know that
has-
we've been advised, I know in my time, we've been advised when we do not go out on an enforcement order unless we contact Ed first and get permission to go with them on an enforcement order. So we only go, I think, right, other commissioners, we
Yes.
only go if there's an RDA or an NOI.
Correct.
Okay, thank you. Thanks, Kate.
Well, let me just pursue that for a minute. Kate, I thought you said that in spite of the form that you helped us develop, that we should be setting up a time to make a visit to the property with the property owner?
Not
Did I
with
understand?
not with the property owner necessarily having to be present, but yes, it's best. They don't have to be there, but it's best for you to call or write, email, however you communicate with them, and set up a time and date that you're going to come by the property.
Well, let's see, I haven't done that, but I can imagine it would be quite a challenge because of the site visits that I've done. Very few property owners are around. They're in Florida or, Jamaica or wherever.
Luis,
So-
I've never done it either. I know we've got to be reasonable. We can't go, at midnight on a Saturday night because I think the
No.
form says reasonable access. But I agree with you, Luis. I've never before asked or notified anybody that I was going, as long as it's, middle of the day in the middle of the work week kind of a thing.
Right, and we
I-
always go to the door and announce our presence.
Yeah.
So it's not as if we're wandering around. So I guess I'm asking, is that that it sounds like you want us to change that? You feel we should?
No, I'm not really saying that. And I was talking enforcement a little bit there versus, there is a distinction here when somebody has an application before the commission. And I don't have that form in front of me that we developed, but I do recall there were several different, we didn't want it to be too specific. But if the property owner is like you described in Florida, they're not even home, then they're not necessarily going to care when you go on their property. Part of it is a protection for the commission in case they have an open pit in the backyard that they forgot to mention, just it's sort of a safety thing so that you're not, or like John said, you're not going to go at midnight or on the weekend. But no, however you work it out with the property owner, when they file their application, you could ask them in the very beginning, okay, if we need to go on site, are you okay with us just going on our own and viewing the property? And
Okay,
if they say yes, then that's fine. That's all you need to do.
Right, but that wouldn't be us. That would be the staff who receives the applications, right?
I think the form generally says that, doesn't it, Darcy? The new form?
Are we
Reasonable
covered?
access.
It says, visits will occur during daylight hours on either weekdays or weekends as necessary for the commission and its agents to examine the said property. I understand that if attempts to contact me are unsuccessful, the commission or the agent may proceed to inspect the outside of said property under this application. And we had a lengthy discussion on how it would be difficult for the commission to contact every homeowner and the homeowner getting all these calls that they wanted to come out and see a piece of property, that was not going to happen. I don't see the commission sitting down and making phone calls. I think there was an agreement that the commission would at least knock on the doors if somebody was there. That's the way I believe everybody's been doing it.
Right. I think that's why we developed this form. I think the form kind of says everything it needs to say. If the applicant signs something in the beginning, that's it. You don't have to do any more outreach.
Right.
I was talking more enforcement, which I know Tom said we didn't need to get into because Ed handles enforcement. So the commission
Tom
doesn't-
made it clear to us, and another commissioner earlier in my history, we used to go on enforcements, and Tom made it very clear, I think, to all of us that we don't go on enforcement unless we go to Ed first and ask for that, and Ed will usually contact somebody and say, I'm going to bring a commissioner with me. So I think
Right.
we're all pretty clear in that rule.
Right. So the form that we developed, I think, solves the problem. I'm not saying to do anything differently, Louise, or have call the property owner in every situation. I think that's why we developed it, because Barnstable does things a little differently because it's a seasonal town. There are people that own property that don't live here for a good portion of the year. So you're not going to be able to get permission to go on the property and arrange it at a time and date that works for the property. And that's fine, as long as they sign something up front so that you don't have any problems later where they claim that you came on the property and shouldn't have. That's why we developed the form. So you should be good with that.
Right.
Yeah, reasonable. Thank you.
Sure. So the next couple of slides just talk about, again, it's more stuff that staff does. And I'm happy to give you this PowerPoint later if you want to have it. 'Cause I'm
Thank
gonna
you.
go through some stuff. I might even just give you the whole thing because, like I said, it's one that I've done for MACC in a full day, a 9 to 5 training. So that's why I broke it up, because that's obviously not going to be done in an hour. But the notice and publication is something that staff will take care of. Then the agenda, you just have to be careful when you're when things are put on the agenda. Public session is the main number of items are going to be public session. Executive session is only typically for a commission of the, used to be 8 reasons to go into executive session, and now it's 10, or maybe it's the reverse. But in any event, the open meeting law was amended a few years ago, and maybe like 2012. And now there are a different number of reasons to go into executive session. But for this commission, it's mainly going to be, for most commissions, it's going to be litigation strategy and sometimes discussing the purchase of real estate, because either of those, your position could be detrimental if it was discussed in an open session. And we've had some litigation executive sessions. We haven't really had any to discuss purchase of property, but that's because if you're in negotiations about the price of a property the commission might want to purchase for open space, you wouldn't want to have that in public session because you sort of hurt your bargaining strategy. And then other items the chair does not reasonably anticipate. If those can be discussed, if something comes up at the last minute, the chair can raise it. And what I usually recommend is raise the item, but say it'll be put on an agenda for a future meeting, because that way you're not going to have people saying, wait a minute, I didn't know anything about this. And obviously it depends on what the issue is. If it's like, should we start a recycling program? That's kind of one thing. But if it's, should we do something about the eutrophication in this pond that has a bunch of residents living around it, people might have a more personal view of that. So if the chair anticipates something within 48 hours of the meeting, you should amend the agenda to put that on. Now, an open meeting law, which I'll try to go through sort of generally, was amended a few years ago. To certain things were changed, but I don't think it really matters what has changed. I think for the commission now, we just need to care about what are the requirements. You have to comply with the open meeting law if you are a governmental body. So it includes every town board. It applies to state agencies as well, and also subcommittees. In other words, if you're elected officials, well, unless you're a board like town council, they're subject to the open meeting law. But staff are not subject to the open meeting law. So I can talk with, as long as it's less than a quorum of the commission, I can talk with the chair and the manager or anybody else who's staff, and just the chair. We're not a quorum of a body meeting. So for the open meeting law to apply, you have to have a quorum, and that is, with respect to conservation commissions, that is typically considered to be a majority of the members then in office. So if your town council appoints or develops a commission that's got 7 members, but you only have 5 because nobody ran or nobody applied for the position, and so you've only got 5 filled, the quorum for a meeting of a conservation commission is considered 5. And that's why I sent you that 6-page letter, because there are many nuances of what is considered under the State Wetlands Protection Act to be a quorum and what is generally considered to be a quorum for other boards. Typically, boards and commissions a quorum is considered a majority of the appointed positions, even if some of them aren't filled. And that can become problematic if someone needs, like, if it's a zoning board and they need a special permit and they need to have a super majority of the board. If if only 5 of the 7 positions are filled, and then not everybody shows up for a particular hearing, that applicant is going to have a hard time trying to get the vote that they need. So again, for the open meeting law to apply, you have to have a quorum of the board or commission. You have to be deliberating on something. So like right now, if someone wanted to claim that there was a violation of the open meeting law for some reason, they couldn't, because this is a presentation. I'm talking, you're asking questions, throwing out ideas, but you're not deliberating on something that you're going to vote on. So that's key. It's got to be a deliberation toward a decision. And that means either an advisory opinion on something or an adjudicatory decision, which is a decision on one of these applications, whether it's an NOI or an RDA that's before you. And it has to be a matter that's within your jurisdiction, but the open meeting law does not include, and this is a tricky one because I'm saying it, but it's a real gray area. It does not include site visits unless you have a majority of the commission go on a site visit and talk about it and throw out opinions. You can't do that. When we've had people apply for superseding orders of conditions to DEP after they get, denied by the commission and they don't like the denial, they'll apply to DEP for a superseding order. Or if the commission, which it hasn't, but if the commission were to forget to act under the local ordinance and just forget to act on an application in general, the applicant would have the right to go straight to DEP, forget the ordinance, and just get a superseding order of conditions under the act. So whenever an applicant goes to DEP for a superseding order, they have a site visit. And we've always tried, Darcy usually says and Darcy, correct me if I'm not saying this right, but I believe she sends an email to the commission and says, here's the time and date of the site inspection with DEP. The first 3 people that reply that you want to attend get to go because we want to avoid having a quorum. And
Yes.
yeah, and it wouldn't be the end of the world if we had more than 3, because this is a 7-member commission. So if we had 4 members, that would be a quorum. And it's not the end of the world if we had 4 people show up, but if those 4 people were giving opinions and talking about the project, then somebody could rightly say that we had an open meeting law violation. So that's why it's just safer to try to avoid on-site inspections having a quorum. The other things that are affected by the open meeting law, and we can talk about this in greater detail maybe another time. Basically, the way you do the meeting notice has to be specific. The minutes have to have the time, date, and the place the meeting was held, the members that were present and who was absent, and any motions and votes that were taken. And as Tom started this meeting, he asked whether anybody was audio or videotaping. The public has the right to do that as long as they don't interfere with the meeting. And of course, they can't even attend an executive session, so it wouldn't be during an executive session. But the chair has a right to ask who's doing that and have that applicant tell anyone, everyone who's there. So rulemaking authority, the next slide, I think we can skip over because
Can I just ask a question about the minutes?
Sure.
This has come up in the past, and that is, if there is an error in the minutes, should there be a procedure in terms of amending that situation? I mean, we did have a process several years ago, but we have not been using that process recently. I don't know if it's an issue or not. I think that, my feeling, and this is just my personal feeling, that the tapes are our record, and that's the best one for reference. But what about the written recording, the written record?
The minutes?
Yeah.
Yeah, what you should do is when the minutes are done, and the AG has not really come up with what's considered timely, except they have said if the minutes are not prepared within 2 years of the meeting, that's not timely. But they haven't said what's the minimum that you should have the minutes ready. But what the commission should do is review the minutes at a public meeting. And if there are any corrections that need to be made, whoever does the minutes, I believe Kim does them.
Mhm.
Right.
Correct me if I'm wrong, but that person should correct the minutes and then they should be brought back to the next meeting, reviewed and voted on again.
Um,
Does that answer the question?
Yeah.
It does. I don't think we handle it that way.
Well, right now, Kate, as the clerk, so Kim sends the minutes out prior to a meeting that it's scheduled to be voted on. I review her minutes in accordance with what I have on file on my record. If there's any discrepancy, I let Kim know, which is very, very seldom. Thank you, Kim. And she reissues an updated minutes, and then I go ahead and I suggest that we vote on and pass the minutes at the next meeting. So that's the way it's being handled right now.
However, the minutes are very detailed, and
Yes, they are.
I doubt that you, in your notes, have the details that Kim is reporting. And there have been from time to time changes suggested by other members of the commission, I believe. And so they are supposed to go to you with that. Is that correct? And then you go to Kim?
Yes, that's correct. If there's any changes, normally people go to me and they say, you know, this wasn't right in the minutes, and then I go back to Kim with that. That's correct.
I'd like to jump in too, Kate. Many, many years ago, we ran into some problems with this, and I think we're still doing it, Darcy. Rob Gatewood, and with some help from some of the commissioners, added a prefatory note on all the minutes that these are basically Scrivener's notes, and that the presiding document would be the video. So we added that in there because we thought that legally that was, that would sort of cover that in fact the record is not the minutes, but the record before the court would be the video of the hearing, the transcript of the video.
I'm not sure about the Scribner, the note that you just mentioned. I
Yeah.
know over the history, because I've been here a long time, we went back and forth on whether the minutes should have almost word for word. And then we had an open meeting training and we talked with Ruth, and she said, Ruth Wild, and she's like, if any board going or commission, conservation has the best minutes going, and they were fine with us doing
Right.
bullet points, issues discussed, just with the bullet points, because with some of our hearings, they would be so long if you did word for word. And that's the way that we do it now, with the bullet points of the issues discussed.
And for a while, Darcy, if you go way back, we used to have a stenographer come to some of the meetings, and then we said, oh, we can't do that anymore. And so that was dropped. And
Yep.
that's when Rob or somebody was keeping notes, for the minutes. Now, at least we have Kim, which is really a great advantage.
Yes.
Yeah, and that's helpful that you've got somebody who takes the minutes. The issue about stenographers, that I know from several of the litigation cases we've had recently, the applicants often will hire their own stenographer if they think that it might end up going to litigation. And that's happened in at least the last 4 or 5 hearings. The ones that have ended up in litigation, I don't know about the ones that were not litigation. Maybe they didn't have transcripts, but the commission still has to have its own minutes of the meeting, but the transcripts are not for the entire meeting. They're just for that one hearing.
Jason.
But a lot of the applicants have been requesting transcripts because it does seem to help if a case goes to court, to when we write our briefs to be heard by the judge, after oral argument. These kinds of cases are not trials. They're what they call motion for judgment on the pleadings. The commission submits the entire record of proceedings. And if the applicant has requested a transcript, that gets submitted to the court, as well as everything that was submitted, the NOI itself, every letter that was submitted, presentations by the applicant and their consultants, any other letter that was submitted, maybe the Shellfish Constable might weigh in, anybody else who issued an opinion, they throw in stuff from the state, and like you might have Division of Marine Fisheries weighing in, and then after the record is produced and submitted to the court, the plaintiff, meaning the applicant who's appealing the commission's decision, they write their brief, and then we have 30 days to write an opposition brief. And a lot of times what I end up saying is that what DEP decided under the Wetlands Protection Act, or what they might, because sometimes they'll go to DEP and get a superseding order, and then they tell the Superior Court under the ordinance appeal, oh, well, DEP approved the project. And then I argue, well, that doesn't matter because they have no authority under the local ordinance. DEP and the commission have dual authority under the Wetlands Protection Act to enforce the minimum state requirements, but then the commission has sole authority to impose the more stringent conditions under the ordinance. So they put in a lot of things that I'll object to, and then both sides end up citing to things that were said in the transcript. So that's how I've gotten to know a lot of your backgrounds, because I read all of those transcripts when these go to court, and the things that you say at the hearings, a lot of times I'm quoting them in the brief. So,
Kate,
yeah.
given the tapes record everything, why can't we have a less detailed transcript? I know you've said that you use those transcripts for hearings at the court level, but you could just as easily give them a section, the relevant sections of the tape. And
Not up to me though. If the applicant, this is in the state statute and it's in the Superior Court, it's called a standing order. It's like rules about how to handle these kinds of hearings. The applicant has the right to request a transcript of the hearing, not just the recording, but they decide this before the hearing, obviously, so that they can have someone there transcribing the hearing and then writing out the transcript. So it's all written in paper. So they do that. Where the commission doesn't pay for that, the applicant does.
right, but so the applicant needs to do that himself.
Right.
So given that we have the tape at our disposal, I'm wondering if we could not be as detailed as we have been in terms of the written minutes. That we would still say, well, this is what's being considered. This is how the vote came out. Maybe a list of the people who made presentations, but not have to go into so much. I mean, some of the minutes are like 5 or 6 pages of some of our evenings. And I'm just wondering, given the accuracy of the tapes, and it's available, you can, get it on your TV screen.
Right. Well, like we discussed, the minutes don't have to be that detailed. You do have to have the basic, some of the things you just said. You have to, who was present, who wasn't there, what was the application for, what property, what's the relief they were seeking, who spoke on their behalf, who else spoke. But then you don't have to get into the detail that are in the transcripts, but you got to remember that not every hearing, like one meeting, the minutes are of the whole meeting, and each meeting has a bunch of different hearings. And not every hearing is necessarily going to be transcribed because the applicants aren't always going to bring a stenographer.
Right.
Or record the hearing. But yeah, you could absolutely make the minutes less detailed. They don't have to be verbatim, and they don't even have to get into every little discussion.
Which
I
is
mean,
what
I've been
that they've tried to do, Louise, with
what?
Kim. As Darcy said, they just use bullet points.
Right.
Right. But I've been a member of certain groups where the feeling was it's better not to go into so much detail because to the extent that there's potential for error or misunderstanding or just the windage that's put into some of those details that can get you into trouble in the future. So it just seems to me like the tapes would be the way we would want to go with,
But isn't that what we're doing?
no.
Because I know we cut back significantly, and Darcy, you help out here, but all she's doing is hitting the bullet points without saying that, what the commission said on each one. I don't know. Darcy, you have to jump in here.
I believe we've cut it back as much as we can because I think you're supposed to at least kind of get a person can pick that up and get a gist of what, like who didn't attend a hearing about what was brought up. So I'm not sure that we can reduce it anymore. I think Kim does an excellent job.
She does. She does a wonderful job. I'm just wondering if it has to do.
Yeah, I don't know that's up to Kate is whether if you can just not even do the bullet points and just say it's on the video. I don't know.
I
No,
would
you
do
have
both.
you have to summarize things
Yeah.
No,
Okay.
yeah.
minutes.
Yeah.
I would
I
be
think-
more than happy to cut all that out of this. I'm sure you would.
I
Sure
think
you
Kim's
would,
doing a
Kim.
great job. I just think they're probably we're splitting the baby just about where it should be split.
Yep.
Opinion.
Because we have to kind of provide a brief summary in terms of what the discussion is in terms of the meeting, and then we have the videotape as a backup in case we have to go back in detail. So
Yeah.
All right, thank you for
Great.
that discussion.
So if we can skip ahead a little bit, we've talked about a lot of things, which is great. I like when the discussion gets going and then we do stuff out of order. So we talked about opening the hearing. Tom's got that covered. Close. Yeah, Darcy, just go to the slide that starts opening of the hearing. Yeah. The point here I want to make is just that be really careful that you do close a hearing. I have seen cases in which there's a lot of reported legal decisions in which a commission thought they closed a hearing and didn't. So, make sure you always get a motion and a second and then a vote to close the hearing so that it's not just kind of left open. I've had litigation myself on a different Cape Town where the applicant, I think, confused the commission into thinking they had closed the hearing and they didn't. And those deadlines are very specific. Next slide about deliberation among board members. I think we talked about that. Follow the DEP rule of the quorum being members then in office, not just how many seats the town council appointed. And that's just a sort of an idea of what's the majority depending on the number of members on the board. Continuances, we talked about this a little already, but and I know the commission has a procedure for granting continuances because we developed a form on this as well since I've been with the town. But just make sure that you don't grant a continuance, even if the applicant's consultant begs you to grant them a continuance on an RDA, because you cannot. Under the wetlands regs, you've got to make a decision within 21 days. And if you need more information to make a decision, then you have to deny it. And then it gets appealed, and at least you didn't lose the opportunity. Post-hearing. These are all topics that we could have like a whole hour on, but the post-hearing, drafting the decision is very important and you guys do a good job at this. You state the standards to be applied. You issue a decision, as I mentioned earlier, you can have an application that's the same exact project. You can grant it under the act because that's the minimum statewide standards, but you might deny it under the local ordinance or the Chapter 703, the private docks and piers ordinance, if that's what the application is for. So state the findings of fact and the standards, like whatever the performance standards are that apply, or the presumptions that are in the ordinance, and then apply the standards to the findings, which you guys do. Other things, the next slide, other things to consider. And I won't go through each of these, but these are things, just in the interest of time, these are things that you can look at, and I will send you the PowerPoint. But one thing I do want to state, and I don't think Barnstable does this, but I've represented many commissions that think that the chair can only vote to break a tie. And that's not true. It's helpful if there is a tie amongst the commission, but it's certainly not necessary. And there's no reason that the chair has to wait until everybody else votes. You can certainly all vote at the same time. But I've seen commissions where the chair thinks he's not allowed to vote and can only vote to break a tie. So just in case anyone thought that, no, that's not true. We've talked a lot about the open meeting law, so I think we can skip ahead to maybe just the one that's notice requirements. And this, you may all be pretty familiar with this, especially newer members of the commission who weren't operating under the old open meeting law. It's 48 hours, but now you don't include weekends. So it used to be if you posted something on a Friday afternoon for a Monday night meeting, that was fine. But now the weekend is not counted as the 2 days. So Friday afternoon, you go, Monday would be the first day, Tuesday. So if something was posted that late without counting the weekend, the 48 hours would mean the earliest the meeting could be would be Tuesday. Notice requirements we've kind of talked about. So Darcy, can you skip ahead to posting requirements? And we don't really need to spend a lot of time on that, but that is something that changed where there are now specific places, and I've listed them here. Under the new open meeting law, you have to conspicuously post something about meeting notices, conspicuously visible to the public at all hours in or on the municipal building. And you have to have at least 2 ways of posting things, because if, for example, there's a snowstorm and people can't get into town hall, and the way that you post your meetings is on a board inside of town hall, you got to have something else. Most towns have a website or something online that people can access. So that's important. Conduct of a meeting. And again, we talked about some of this already. People still need permission of the chair to speak. And we talked about, asking if anybody's doing a recording. Executive sessions, we also talked about this, so I'm going to skip ahead. Unless anybody has questions about the conduct of a meeting or the purposes of executive session.
I have a quick question.
Or
Thank you. Angela Taney. 48 hours notice for the meeting. Does that go for the agenda as well? Posting the
Yes.
agenda? Okay,
yes,
thank you.
it does for both. And as I think we discussed a little bit earlier, if there's something that the chair realizes and there's still 48 hours before the meeting that is likely to come up, then you should amend the agenda. And the agenda can be amended less than 48 hours. Just the idea being give people as much notice as possible.
Okay, thank you.
Sure. There's a discussion in here about remote participation that I'm going to skip because COVID changed everything. This all still applies, but COVID made it even looser. So towns can sort of do kind of anything right now as far as fully remote, fully in person, and hybrid is even still happening in some places. But I think I know we're trying to get down to pick one or the other. Quasi-judicial boards. And this gets into a little bit of, so a quasi-judicial board means you're the kind of board like zoning and some others that are making basically adjudicatory decisions. You're making decisions whether to grant or deny a permit to someone, and therefore it can end up in litigation. So these meetings are covered by the open meeting law. And we can skip over the definition because we talked about what you have to be a meeting. It's got to be a meeting of a quasi-judicial board or commission held for the sole purpose of making a decision required in an adjudicatory proceeding brought before it. And conservation commissions are amongst the boards that are quasi-judicial. So there has been an appeals court case, and this is an important one. And actually, Barnstable has something that's even more stringent with respect to the Mullen Rule. The Mullen Rule was adopted it was the town of Brewster that had a situation where a member was not able to be in attendance at every hearing. And in that case, the court developed a test that basically said, as long as, not so much a test, but a requirement that as long as the member who missed the meeting reads all of the submittals looks at the recording, everything that was part of the meeting that they missed, and signs a statement. And every town, puts together its own kind of statement where they sign their name, the date of the meeting they missed, and they swear under the penalties of perjury that they reviewed all of the information. Then they're allowed to participate, even though they missed that one meeting. Barnstable goes one step further, and I think that this is a good thing to have, which is a rule that only one person can mullen in, as we say, so to each hearing. So you can't have two members do the same thing. The one person who misses a hearing, they read everything, they sign saying they did, fine, they're back on the board. If somebody else misses a hearing, that's a problem. And usually what'll happen then, because the applicant is the one that suffers in that case, because they'd have to start all over again. In that case, if a second person can't make a meeting or a hearing on the same application, then offer a continuance. Obviously not if it's a request for determination, and you can't, there's typically no continuances of those anyway, because it's such a short time frame. But a notice of intent can be continued. So if you find yourself in a situation where a second person has to miss a meeting, that second person is not going to be allowed to sign the Mullen statement. So the only thing you can really do is continue it. And adjudicatory proceedings result in decisions either to grant or deny. So it's probably going to, I'm looking at the clock, it's probably going to be a topic for the second session training, but I want to talk about drafting a more stringent ordinance. And you already have a decent ordinance, but I just kind of want to explain really like the 5 main things where your ordinance can be more stringent than the act. I am going to do talk about one more thing on here before we get into the adjudicatory stuff. But if you have a more stringent ordinance, when you're reviewing an application, keep in mind that if it gets appealed, there are going to be 2 separate appeals. The decision under the act, unless it's a grant and no abutter wants to appeal it, but if it's a denial under the ordinance, that goes to Superior Court. The one under the act goes to DEP on appeal, and the decision under the ordinance goes to Superior Court. Just jumping back to open meeting law, the appeals court did find there's a situation in the city of Boston. It was a city council, but this could apply to a conservation commission or any board. They held meetings where they were closed to the public, and they had a rotating quorum. This is just an example of sort of an extreme violation. It's back in 2008. Only a minority of members were able to consider matters, and they rotated, like they would have a majority in the room having the meeting, and then next time they would have the next group of people. So it was a clear violation of the open meeting law. It's not something that we need to worry about, but it's just something to be careful of. Another thing to be careful of, and I know Darcy's got a good system where if an email goes out and it's distributing information, that's perfectly fine to do. The only problem that could arise is if people start replying and giving their opinion on it. So she'll write, please do not reply all. Dissemination of information can easily be done without violating the open meeting law. The problem comes in if someone submits and we've had this happen in Barnstable. If somebody submits an article, which is opinion, and maybe there's another article that's completely contrary as far as the science, and someone says, read this article, this is why we should do this or that, and states their opinion on it, that alone is an open meeting law violation if it gets challenged. And then if people start weighing in with their opinions on it and arguing about it, that's like you're deliberating on a matter that's before the commission. So that would be a violation. And the same with what's called serial communications. If one member emails another and talks about their opinion on this particular application, and then the second member or the first one emails another member and sort of gets their opinion on it, that's a violation of the open meeting law. And whether it's done over the phone or by email, that's considered a serial communication where you're trying to avoid having a quorum altogether, but you're talking one at a time to each member. What you can do if you need to convey information to the rest of the board is call Darcy And she can then, again, not opinion, but she can distribute, like my article today that she sent around to everybody. She can just distribute information, and it's not something that you're going to be deliberating on. Probably for the next time, I do want to get into how to prepare a strong decision for court. And part of that is having a strong bylaw. And the main things that make a bylaw stronger and more stringent than the Wetlands Protection Act are things like a stronger burden of proof. Do you have resource areas that are protected in addition to the 8 that are protected, or however many there are? I know there are 8 interests of the act, 8 values, but there's about the same number of resource areas. Commissions can add to those. You can have, like, we have shellfish habitat, additional values that are protected that DEP doesn't protect under the act. And you can also have additional resource areas. Like the biggest one is buffer zone. DEP only protects the buffer zone if the proposed project is actually going to alter it. Whereas if a conservation commission puts the buffer zone as a separate resource area in its ordinance, then you can regulate the buffer zone more stringently than DEP can. And one important thing to keep in mind is, and I was surprised at there are a number of attorneys that were not aware of this. Maybe 20 years ago when I was practicing, there was a case that came out that I thought was obvious, but it just showed that a lot of people were not aware that you can't just deny something because your bylaw is more stringent unless the more stringent provisions apply to the particular project. So for example, if you have the buffer zone and habitat as a resource area and a value, but the particular project that's before you is nowhere near the buffer zone and has nothing to do with habitat, you can't deny it based on that. It has to be denied because something in the project directly impacts something that's more stringent about the local ordinance. So there are, we can get into more detail about the things that you want to do to have your bylaw be more stringent or your ordinance. Another one being, if you have a variance provision, you got to be really careful that it's only giving variances for specific provisions of the bylaw or ordinance, because some municipalities grant variances and they end up granting a variance from a provision of the State Wetlands Protection Act, which you can't do. You can be more stringent, you can't be less stringent.
Right.
So it's been an hour. I can take questions, and then I think we need to schedule another one to talk about more stringent bylaws and then how to get ready for court.
Thank you, Kate. Any
Michael?
questions, Kate?
Meg, yes.
John?
Kate, you may not want to get into but the document you sent out, which I printed out and then read a couple times, I have one question that I'm confused about. Can I ask that now, or would you like to wait for another meeting?
Is that the quorum and quantum one?
Yeah, that's the quorum, and
Yeah.
the specific question relates to a positive, an affirmative decision.
Okay.
How many members does it require to give you an affirmative decision? That's that area I have one question on.
Okay, go ahead.
Okay, you made it clear. I think you made it clear that it's not the number of possible members, but it's the number of people at the meeting that constitutes the quorum and what a positive means. What I was confused about, if we have 7 commissioners, let's assume that there's 5 at the meeting. How many positive votes to approve an application do you need? Is it a majority of those 5? Or is it a majority, which would be 3, or is it a majority of the 7 sitting commissioners, only 5 of whom are at this meeting, so that would require a positive vote of 4? I was really confused about that, and
Yeah, it is confusing, but the general rule for other boards is, and this is under General Laws, Chapter 4, Section 6, is the majority of the number of slots on the board. And what DEP says under the act is first the quorum is how many people you need to have just to have the meeting.
right,
And that's the majority of the seats filled
right,
or the commissioners currently serving. So that can be less. So if the town has created a 7-member commission, but only 5 of those seats are filled, that's a quorum.
Right.
And then when you get to the meeting itself, the quantum of vote that you need. And I think on page 3, I talk about, I advise the most cautious approach is a majority of the sitting commission, not just those present, because you could have, with this commission, it's 7 and all the seats are filled. You could have a meeting with 4 and a quorum of that would be 3, but that's in the conservation context under the Wetlands Protection Act, that's not considered sufficient to get an order of conditions. It's got to be a majority of the entire board. So it would be 5.
So
Oh,
even that, and we've had this, Tom, come up before of us, where there's 5 commissioners there and 3 vote in favor of it, and we're saying, okay, it's approved. And it's a majority of the 5 people that just voted. But I think Kate just said, and that's a question, that no, under all circumstances, you need 4 positive votes, even if there's only 5 in attendance at the meeting. Is that is a question?
I think I'm saying, unfortunately, it's a gray area and a court hasn't ruled on it yet, but I'm just saying to be cautious, you should try to get a majority of the entire board granting orders of conditions.
We've had this issue in my time, and I, right, Peter, we have gone with well, if there's 5 people voting, because 2 are away or whatever, as long as you had a majority of those voting, then it was approved. So if there are 5 commissioners that are at this hearing and 3 said, yes, we will approve this, we have said that's an approval. I think that's what we've done in the past. And I was concerned about, right, Bill? And I was concerned about whether that is, it may not be the safest way to go, but is that a legally okay the way to go? Or you may want to come back to us and say, don't ever do it. I don't know.
I think you're okay, but I mean, like I said, I always advise the most cautious approach because the court hasn't ruled specifically on that yet. So you're better off if you do have a majority of the full board. I'll reread my letter and
Well, that would also say, you said if we have 4 present, we can have a meeting. But then the extension of what you've just said is that we have to have a unanimous
Right.
positive vote.
right.
And
Right,
that's
that's
not
the
what we've
problem
done
that
in the past.
applicants face.
Beg your pardon?
That is not what we've done in the past.
Right.
right.
It's been a
Right.
majority of those in attendance at the meeting. So if there are 5 at the meeting, you needed 3 positive votes in an application.
Have 4, you still need 3, but
So that was my specific
Yeah.
confusion, Kate, from reading your document that you sent out.
Yeah,
Can we
many
talk about that more, because that is definitely a big issue. And then, of course, to complicate things further, DEP also in its regs has a requirement that a majority of the commission sign an order of conditions.
Right.
And it doesn't even, you can vote against something and still be one of the members that signs it.
right.
yeah.
Maybe we can get some clarification next time on this quorum issues for the meeting and so forth, because I remember that many years ago when we are meeting in person in the afternoon one, we run into a situation that we only have 4 members to show
Right.
up for the meeting and vote on something.
Some applicants will ask for a continuance so that you can have more members there.
Yeah.
Right.
Makes a lot of
Mr. Chairman,
sense.
I believe Pete had a question. I'm sorry,
Yeah.
Don.
So yes, what I think, John, and I completely agree with what we've done in the past. With 5 people present, we've always considered 3 to be sufficient to have an okay from us. I think the reason why we haven't had any trouble with that is no one's challenged our decision.
That's true, Pete.
I suspect if someone wanted to challenge it,
Yeah.
they could, but no one ever has.
I think you're absolutely right. And that's why when I read Kate's and I read it my confusion, I wasn't sure of what the right, I know clearly, Kate, you're right. It would be better to have, a majority of the 7. But if we're stuck with a situation where there's less than that, there's only 5 members, can 3 give a positive answer? That is the question that I'm asking, that I was really confused about. And as I said before, we have done that, right? As Peter just said, has been our position.
Right, and nobody challenged it, so.
Nobody, and exactly what
Okay.
Peter said, nobody's challenged it, so it's, it's okay.
Let me for next time see if there's any more recent case law, although I think I would have heard about it from my little MACC group. But if there's anything more recent on it that addresses it more specifically than just be more cautious. Some applicants will ask for a continuance to get
Yeah.
more members present.
Right, right.
We have even said, Tom, we've even said to an applicant, we would recommend, because there's only 5 of us here or whatever, that you may want to take a continuance, but that is up
Right.
to the applicant, you know.
And under the statute for the zoning boards of appeal, applicants for special permits need a specific number depending on the number of people on the board. So like if it's got to be 4 out of 5, it's a 5-member board and only 4 of them are present, unless they know they're going to get a unanimous vote, they'll ask for a continuance. Because
We don't have that limitation.
Yeah, we don't have.
Conservation doesn't have that specific limitation. That's in the zoning context, you definitely see that happening, asking for
Right.
continuances.
But it has to be a continuance before the hearing opens, because otherwise you get the Mullen rule involved, which says you can only have one person mulling in. So you still might be stuck.
Right, but at least they can get one more.
Right, right.
Well, but you know, now you've got 6.
Right.
You know, whatever.
Whatever. Well, thank you, Kate. That was my.
Thank you, Kate. Thank you, Kate.
Have a great evening and rest of the meeting. And
Thank you.
again,
Thanks.
you're welcome.
We'll
Good
get
night.
the second meetings.
Sure.
So we go back to the public hearing. We have 4 RDA. The first one is Laura Cofertos Sperry. Failed septic system upgrade at 43 Locust Avenue, West Barnstable, as shown on the assessors map 197, parcel 027. Darren?
Hi, Darren Meyer here. Can you hear me okay?
Yes.
I'm here representing the owners of 43 Locust Avenue for a septic upgrade. The current system is failed. This is a 3-bedroom existing dwelling. The plan is to replace the components, tank, pump chamber, and leaching. All 3 need to be replaced. The only component that's within your purview would be the septic tank itself. That is within the 100-foot buffer, about 92.6 feet away from the inland bank across the back of the property. The tank will gravity feed to the pump chamber, which will then pump over to the leach field on the southerly side of the property. It's a 3-bedroom dwelling, as I said, and there's no proposed increase in flow. The work areas noted on there. Plan is to just do straw wattle around that work limit line to protect for any, runoff or anything like that. We're headed to the Board of Health on the 27th for their review and approval. So I'm happy to answer any questions.
Thank you, Darren. Any question from the commissioner? Seeing none. Any public comment? Channel 18.
Seeing none.
Thank you. Could I have a motion to approve this project as a negative determination?
So
So
moved.
moved.
Second.
Roll call.
Sampo,
Aye.
Tangny,
Aye.
Lee,
Aye.
Hearn,
Aye.
Gilmore, aye, Foster,
Aye.
Abadili.
Aye.
That's unanimous, Mr. Chairman.
Thank you, Darren. Good luck.
Thank you.
The second RDA is the beach clubs to extend the fence along the property line at 27 Long Beach Road, Centerville, as shown on the assessors map 206, parcel 016. Jim?
Yes, can everyone hear me?
Yes.
Thank you very much. This is just to put a stockade fence on our existing property line.
How long is the stockade fence?
It's approximately 125 feet.
Okay.
What's the resource?
Pardon me?
What is
What's
the
the source?
The resource?
It's a it's definitely a flood zone and it's a beach area. This is
we
at the
need-
beach club.
Do we need the 6 inches, Darcy, under the?
That is going to be difficult. They get a lot of sand that blows around, so I don't think I would. I think it would be very hard for the applicant to have to deal with trying to maintain a 6-inch clearance when it's just a section between the beach club and the abutter. So,
Thank you.
yeah.
What's the length of the fence now? You said it's going to go to 120 feet, 5 feet. What is it now?
There's approximately, I would say, 1/3, or just shy of half of the fence that's there. There are some existing panels that are there that are going to be moved back onto the property line.
Okay, so you're doubling the length, more or less, right?
Not necessarily, because you can't see it in the photo there, but kind of where there's a bocce ball court, there are already a few sections of fence there. So we will be repurposing some of that. It's just not a complete fence.
Right. Pete?
Actually, Abo already asked a question, or someone did about, or Darcy, that 6-inch rule underneath or a 6-inch request underneath.
Open.
Yeah, opening underneath, and I guess that's gonna be a difficult thing to, so we're making an exception here.
Right.
Okay.
Thank you, Pete. Any other question from the commissioner? Channel 18, any public comment on this?
Seeing none.
Could I have a motion to approve this project as a negative determination?
So moved.
Second,
Roll call.
Abadili,
Aye.
Tangney,
Aye.
Sampu,
Aye.
Foster,
aye.
Lee,
Aye.
Hearn,
Aye.
Gilmore, aye. That's unanimous.
Thank you. Good luck, Jim.
Thank you, everyone. Have a great night.
Yep. The next one is Dewey Gardens LLC, vista pruning of bank between lawns and contoured bay at 621 Old Post Road. Contoured as shown in Assessors Map 054, parcel 015-001. Dan.
Good evening, Chairman and fellow commissioners. Thanks for your time this evening. I'm here on behalf of Dewey Gardens as well as our customer, Charles Rogers at 621 Old Post Road in Catuit. We are looking to gain approval for some vista pruning of the embankment between a section of turf and Catuit Bay. I'm happy to address any questions that the commissioners may have.
Thank you, Dan. Any question from the commissioner?
Yes.
John?
Yeah. All I saw was the 3 arrows. I have no idea of the width of those. Is that 1/4? Are you asking for any exceptions from the vista pruning guidelines? Or is it all standard vista pruning within the current guidelines?
It's all standard within the current guidelines, so 20%, no more than 20%. And there are 3 oak trees and 3 cherry trees that fall on the embankment. I did send a few photos to Darcy. I don't know if she has those available for us to take a look at.
What time did you send those in? Because I can't find them. I was looking for your email so I could put it up and,
But yes, John, to your question, it would be, the work that would be done would fall under the guidelines that are provided within the vista pruning guidelines.
Darcy, I didn't get to the site. Darcy, have any comments relative to the corridors, the width, et cetera?
no, he labeled the 84. Emil met him out on site. So Emil went to this one and he said everything looked fine. And I'm sorry, Dan, I did not find the photos that you sent. I would have put them up. I have a 2014 photo from assessors, but I think this is just standard.
Yeah, I can try sending them again because I sent them at 1:30, so a little bit late. My apologies for that. But I'll try and sending them again for you.
Thank you, Dan.
Yep.
Luis?
I was confused a bit by your project description. You say that remaining branching will be left in place to promote branch stability. What do you mean by that? I mean, it could be interpreted as the branches that you cut off, you're keeping them there on site. Is that what you meant?
Yeah, so I think what it said in the application was that branching less than 3 inches in diameter would be left on site. My mindset behind that is that this site it's a very steep incline leading up from Katuitt Bay. And my mindset actually was for the benefit of the resource area, just because it's so steep. There is, a fairly successful layer of shrubbery and undergrowth in the understory. But my logic was more along the guidelines of having that organic matter there, as well as being able to provide some structure to that bank. Certainly, if the commission feels that that might not be warranted, obviously anything larger than 3 inches would be removed from the site. So that would be in the works. But if the commission feels that that is of no benefit, then everything can be hauled out of there.
I worry that there's going to be a lot of dead branches just lying around.
Sure.
On the surface of that area. I don't know how others feel. But then the other thing is, you say all branching over 3 inches will be removed off site. You referred to that. It sounded sort of as if that was what you were going to cut in terms of the size of the branches. It just didn't make sense to me. Now, if Emil has been there and he thinks all is fine, Darcy, then
Yes.
fine.
Yep.
But I am concerned about the idea of having a bunch of branches cut off and then just left there.
Sure.
Thank you, Luis. Pete?
Yeah, I'm actually perfectly fine. I agree with Dan that leaving the smaller branches there in a couple of years are going to break apart and add to the organics. It'll help break up rain impacts. I think it's a good idea to leave the smaller branches there. Thank you.
Yes, staff thought it was a good idea too.
Well,
Thank you.
happy.
And Darcy? Bill?
Yeah, I just agree with what Pete said. I think the branches should be fine.
Thank you, Bill. Channel 18, any public comment on this?
Seeing none.
None?
Yeah,
Hello?
hi. This is Sarah Molyneux. My husband, D.F. Law, is also on the call. We are the abutters to the property, and we're in full support of the proposal. Thank you, Tom.
Thank you, Sarah. Could I have a motion to approve this project as a negative determination?
So moved.
Second.
Roll call.
Abadili,
Aye.
Foster,
Aye.
Gilmore, aye. Hearn,
Aye.
Lee,
Aye.
Tagny,
Aye.
Lampoon.
Aye.
That's unanimous.
Thank you. Good luck.
Thank you, Chairman. Thank you, Commissioners.
The last RDA is Anthony Ambrogio and Anchor Visapolos. Removal of oak saplings and invasive species, removal of duck in timbers, plantings of native species in disturbed areas at 580 Lumber Mill Road, Centerville, as shown on the Assessors Map 147, parcel 086. The applicants has requested a withdrawal of these applications, so you can throw away the paperwork. We have one NOI, B. Francis II and Patricia Ezo, proposed removal of invasive species and replacement of native plantings at 355 Yale River Road, Osterville, as shown on the Assessors Map 114, parcel 023. John.
Good evening, Commissioners. John O'Day from Sullivan Engineering Consulting. I'm here this evening representing the applicants. I'll bring up some of the plans for you all. As you described, this is the project at 355 Eel River Road, obviously abutting Eel River. This is a little under a 2-acre parcel that the family has owned for 50 odd years. It's remained relatively unchanged. We're here before you this evening for a little project to remove some of the invasive landscape along the bank and replace it with native plantings. There was a plan and a narrative also prepared by Peter Hansen. He had another engagement this evening, so wasn't able to attend. But our resources, land under Ocean View and Eel River, there's a band of salt marsh, some beach areas, and then there is a coastal bank. So the work is generally in this area dotted on our surveyed site plan, and then I can switch over to Peter's plan, and he has, indicated a limit of work to be established, an access way to get down here. His narrative goes through some of the things that they'll be targeting in removal, which includes bittersweet, honeysuckle, Scotch broom, and autumn olive. Has a planting schedule for what he was recommending as a restoration in that area. We did have one comment from staff, which we haven't quite been able to connect on. There was a little bit of a concern about the proposed bearberries. And I was able to talk to Peter about that. And we're certainly here to work with the commission and the staff to come up with something. In Peter's mind, he was trying to have some variety and some ground cover into this planting mix. There is certainly some bigger things, beach palm, bayberry, Virginia rose. He was just trying to get some ground cover mixed into that too. It is on your planting list. It would do well in the salt and, in that sort of sunny heat environment. It's generally only available in that 1 gallon size. We understand the commission has concerns with that in certain situations. This isn't like the long edge of a lawn. We have a giant hedge above us. If they'd like to see those plantings clumped together more so that they can kind of, 3 1 gallons can be put together to be a 3 gallon, we're open to that. If you wanted a different ground cover, Peter was saying, sometimes junipers can be available in that size. We're open to that. And if you don't want any ground cover at all, we're open to that too. So we're here to just hopefully work out with you what's a good planting plan, and look for your approval.
Thank you, John. Bill?
Yeah, I think the idea of getting rid of the invasives, bittersweet, the olive and whatnot, this is a good idea. But when I look at the plan, it's a fairly steep bank. And I mean absolutely no respect to Peter Hansen Design. I don't know that firm, and I went online, and it's the classic, very I don't know what you call it, like a very artificial upscale landscape. And so the idea of, I would like to see the place run wild with the native vegetation. In other words, you're going to put in these plants, and I think that's good, but I hope there's no like mulch and open area that just makes it all look extremely tidy. I would like for the stability of the bank, you really want to have Mother Nature take its course and grow in there with a lot of, natural plants. So I'm hoping you're not going to be,
I don't think that the vision I don't think the vision is at all for this to be a managed area. As I mentioned, there's a hedge along the top of that bank, so the applicants don't even see the bank, and they have no interest in removing the hedge. They don't want people looking in, even if it means they can't look out. So this is really, in their minds, just about trying to come up with a better natural landscape for the environment.
And I trust that. I just wanted to throw that out. It's a really steep bank, and I just think it really needs to be chock-a-block full of plants. natural plants. Thank you.
Thanks, Bill. Pete?
Yeah, I think again, this is a great looking plan. I like the fact of the removal of all those invasives. I don't see any problem with the berry being just 1 gallon. I don't think you need to clump them into groups of 3. If some of our staff thinks that more than 25 are needed to stabilize the area of exotic invasive removal, then maybe we need more than 25. But there's nothing wrong with a 1 gallon pot of these things because they'll get bigger. So I'm cool with this, and I'm just be looking for staff on site after the removal of the exotics to see if there's more than 25 needed. Thank you.
Thank you, Pete. Darcy, do you want to say anything?
No, I think what John said and Pete is fine. And I would say that we get monitoring reports. And if we believe there still needs to be some like year 2 or 3 additional ones after the first or second year added in there, then if they're open to that, I'm good with seeing how it goes.
Okay, thanks. Angela?
Yeah, thank you, Tom. I agree with Bill and Pete. I had some concerns about exactly what Bill brought up between the walking steps, if that was going to be filled with, mulch and things, but I'm totally fine with the project as discussed. Thank you.
Any other question from the commissioner? So a couple of things I just want to point out, because the work area is going to be upland side of the salt marsh. So we will not require a cert professionals for this qualifications, right? So Peter Hansen's qualification will be fine for this work. And secondly, when they are working in that area that closest to the salt marsh on the upland side, they should provide some erosion control so that to minimize any soil disturbance in that area when he's working in that. So those would be like the condition in there. So the other thing is like if Peter Hansen is the contractor for this job right now, and if there is a change in terms of the contractor, you need to provide a written notification to the staff of the change of the contractor. And we need the annual report. I think that's all I have on that one. But let me.
Tom, you muted yourself.
I actually muted him by accident. I was trying to unmute me.
Oh, that wasn't by accident, Darcy. Come on.
Okay,
Well, I
Darcy.
just wanted to, I'm so
We
sorry.
owe you a debt of thanks, Darcy. Well done.
I was trying to unmute so I could say, we just also want to state, like, he will be noted as the contractor. Any change in the contractor has to come back to staff for approval, not that we just accept the change in contractor. We have to be able to review it and approve it. That's all I wanted to say.
Okay.
You have to go to
any
the public. I think.
John?
You have to go to the public for this, I think.
I know. I want to go to the commissioner and see any more questions before I go to the public. None? Channel 18, any public comment on this?
Seeing none.
None? Let me try this. Could I have a motion to approve this project subject to 1, an annual report for 3 years, and second is Peter Hansen is the contractor for this project. If there is a change in the contractor, that we need a written notifications and approval by the staff. And second is we need to, the contractor should install the erosion control above the salt marsh area to minimize any soil disturbance in that. So that's the motions.
Hold a second. And as Darcy suggested, that if after review, more planting needs to be done to stabilize the bank at year 2
or 3,
that the applicant is open to that recommendation or to that request, open to that request.
I would make a motion to support the modification that Pete suggested.
Second.
Roll call.
Abadili.
Aye.
Foster,
Aye.
Gilmore, aye. Hearn,
Aye.
Lee,
Aye.
Hangney,
Aye.
Zampo.
Aye.
That's unanimous.
Thank you. Good luck, John.
Very much.
We have one continuance, Elizabeth Gold, trustee, to construct a proposed porch at 267 Scudder Road, Austinville, as shown on Assessors Map 139, Parcel 013. This is a continuance from January the 23rd and waiting for the DEP number. And the DEP has issued the number as SE3-6155. Could I have a motion to close the public hearing and authorize the staff to issue the order of condition?
So
moved.
moved.
Second,
Second.
roll call.
Foster,
Aye.
Lee,
Aye.
Hearn,
Aye.
Zampo,
Aye.
Hangney,
Aye.
Abadili,
Aye.
Gilmore, aye. That's unanimous.
Thank you. We have one EC certificate of compliance is Europe and Nere Anata SE3-5660. Could I have a motion to approve?
So
So-
moved.
Second.
Roll call.
Abadili,
Aye.
Foster,
Aye.
Gilmore, aye. Hearn,
Aye.
Lee,
Aye.
Hangney,
Aye.
Zampo.
Aye.
That's unanimous.
We have two sets of minutes, January the 16th and January the 23rd.
I make a motion, we accept the minutes as submitted.
Second.
Roll call.
Zampo,
Aye.
Hangney,
Aye.
Lee,
Aye.
Hearn,
Aye.
Foster,
Aye.
Abadili,
Aye.
Gilmore, aye. That's unanimous.
Our next hearing is at 3 p.m. on the February the 13th. And I will miss that hearing. I will be in Toronto for the Chinese New Year. Happy New Year.
Happy
Could I have a
New Year.
mo-
New Year.
Could I have a motion to adjourn?
So moved.
Second.
Roll call.
Abadili,
Aye.
Foster,
Aye.
Gilmore, aye. Hearn,
Aye.
Lee,
Aye.
Hangney,
Aye.
Zampo.
Aye.
That's unanimous, and we are adjourned at 8:07.